I found it interesting that a federal court uses a legislator's statement or statements to allow a lawsuit challenging a state statute. So in March of 2023, there was a decision by the United States Court of Appeals for the Ninth Circuit. The case is Olson versus State of California. And here the federal appeals court based its decision squarely on the public statements that were made by the author, now a former legislator, of a bill that was at issue in the litigation. The decision is interesting for my purpose, not only because of the subject matter of the bill, which was a controversial measure that was hotly contested in the legislature, but also because of its use of an uncommon means of considering legislative history. So this concerned Assembly Bill 5, and it dealt with the misclassification of independent contractors, as well as the codification of a prior California Supreme Court decision called Dynamex Operations West. And basically, the legal challenge, the lawsuit by Olson against the state of California, was brought by two app-based drivers on several grounds. And the federal appellate court ruled that the state statute may actually violate the equal protection rights of these drivers who were independent contractors for gig companies. And the federal appellate court ruled that the plaintiffs had alleged and that could be maintained, that AB 5 unfairly targets app-based drivers and their companies like Uber and Lyft. Now, what I found most interesting in the reading of the case is that the Ninth Circuit panel found that the legislator that expressed publicly a desire to harm app-based drivers and their employers. And so the court specifically cited statements that were made by the former assembly member and the author of that bill, AB 5, that she had actually singled out and publicly disparaged those app-based companies. And that was the evidence that the Ninth Circuit found was the primary purpose of AB 5. It was based on what they called an animus towards these companies. And therefore, the plaintiffs had in fact stated a cause of action under the Equal Protection Clause. Here's what the appellate court wrote. They said, the sponsor of AB 5, California Assemblywoman Lorena Gonzalez, published a Washington Post op-ed in which she proclaimed that AB 5 would guarantee workers the normal rights and privileges and benefits enjoyed by most employees, but that gig companies such as Uber, Lyft, DoorDash, Handy, and others do not provide to those gig workers. And the court said, according to a December 2019 Los Angeles Times article, Assemblywoman Gonzalez was open to changes in AB 5 next year, including an exemption for musicians, but not for app-based ride-hailing and delivery giants. The federal court also noted that California Assemblyman, who is the speaker, tweeted, Anthony Rendon tweeted, the gig economy is nothing new. It's a continuation of hundreds of years of corporations trying to screw over workers. With AB 5, we're in a position to do something about that. So as a result, the Ninth Circuit panel said, even under the fairly forgiving standard of review, we conclude that considering the particular facts of this case, plaintiffs plausibly allege that AB 5 as amended violates the Equal Protection Clause for those engaged in app-based ride-hailing and delivery services. The court also stated, we recognize that we recently rejected an equal protection challenge to AB 5 in the American Society of Journalists and Authors case. However, plaintiffs' plausible allegations of Assemblywoman Gonzalez's animus against them distinguish the two cases. Additionally, the federal court said, plaintiffs plausibly allege that the primary impetus for the enactment of AB 5 was the disfavor with which the architect of the legislation viewed Uber, Postmates, and similar gig-based business models. However, the publicly articulated purpose of AB 5 was to ensure that workers who are currently exploited by being misclassified as independent contractors instead of recognized as employees have the basic rights and protections they deserve. AB 5 said that, but as the plaintiffs plausibly alleged, the exclusion of thousands of workers from the mandates of AB 5 is starkly inconsistent with the bill's stated purpose of affording workers the basic rights and protections they deserve. Now, again, from my perspective, it's noteworthy that historically California courts have disfavored using an individual legislator's statements, even the bill author, to ascertain the intent of the legislature unless those statements are known to have been made to the legislature as a whole. For example, were those statements made on the floor of the Assembly or Senate? Were those statements contained in a legislative bill analysis, particularly the floor analysis? Now, technically, this case was not one of statutory construction, obviously, but what makes it interesting nonetheless is the reliance that the federal court used. They used the bill author's public statements to support the alleged violation of the plaintiff's equal protection rights. So here the federal appellate court gave great weight to the bill author's statements, which appeared in a national newspaper as well as one in a statewide newspaper, and there was also a tweet from the Assembly Speaker. So in that regard, although the individual legislator statements were used to undermine the legitimacy of the statute, the statements were also of value by the court, which is a welcome approach from my perspective by the judicial branch of the government.